So now autumn 17, 13 want to stack up their names from the list of the itself. Then they become a
You will have to file an IA.
IA.
Yes.
One IA will cover.
One IA will cover. After that,
Well, this is motion matter listed on 6-1.
Hmm.
On that time, my legal asked for the timing, but case was passed over. So if we can be listed on the 8. It is in motion list.
11th on 13th.
There is a this is not sheet I issued on 10th of January 2023 was listed. But giving positive time it was left off.
13. 13. Yeah. Yes. Before?
28.
What matter is this? List is case before the appropriate page. Item? Okay, we'll see. Eight. Yeah, 13. 14 is the hearing date. Yeah, 15th.
Mention for listing option. This matter is regarding orders.
13. 1-3.
And another two matter regarding provincial service option.
15th. Item 1-4. Your good name, please. Your good name? MSL Borough, London Council for Petitioner, press for withdrawal of district petition with liberty to file afresh. Press allowed if petition is dismissed on withdrawal with liberty as spread. Okay. Yeah. 15. 15. Yeah. It's a fixed matter. Who's your senior? On request Madam Gao, Mr. A. Kundu, when it comes to the petitioner. This the matter after 1 week.
But I still matter for motion. But what is that way? The petitioner have been inverted back without any notice. We are holding on the charge. So let's pay.
Fifteenth.
another method where we have participated in a selection process. The other departments, they have given the results. Our results, they have withdrawn it, and they are processing on a press to give a press advertisement. Therefore, it's for motion.
Eight.
I'm paying for listing of 2 meters, like pension meters.
15.
Okay.
Yes.
Item 1 of daily list and 52 of daily list.
This case is not maintainable. Cannot undertake in view of the incumbent judgment.
Okay. That's good.
There is a single judge order. Single judge order was there. Thereafter, that was challenged. The appellate court upheld the order. They were directed to appear to the tribunal. That is the
Item 1. This is item 1. Yes.
On behalf of one of the respondent number 6, and I have recorded. My learned serial page is really wrong. No. I also one respondent. One respondent 7. Not my respected.
Ali here for the petitioner.
I am only petitioner.
Oh.
This one wrongly listed in motion column. Already notice has been issued and there is still marked by form 4.
When was notice issued? Oh. Yeah, it's listed. It should come up for admission.
Yes,
It should come up for admission.
Record was for last order.
1 minute. 1 minute.
Can be.
Yes.
The last order, lordship, see record has been called for. My lord has already disposed of similar cases in many cases, where it is without invoking the application. My lord, this definition has been not material. And therefore, my lord was pleased to dispose of a series of petitions. The same issue of challenge, provincialization of the respondent number 6 and 7. The crux of the case is that he is also teaching the language, and I am also teaching the language, and bypassing the seniority, he has been provincialized. So, the issue can be adjudicated by the appellate authority as the disputed question of facts has also been raised. And the district level executive committee is the recommendation minor is to find a page 47 of the expedition below, wherein the present petitioner as well as the other persons has been recommended, and the petitioner has been treated as a drop petition not eligible for provincialization.
Oh, this is for provincialization.
Yes, my lord. That's what we will ask. It will be again with the same exercise, the record will come, then again we will remanding it to the appellate. Today itself it can be disposed of.
Yes, Ali.
So, here the issue is, my lord, whether English is a language teacher. Under Constitution, English is not a language teacher. So, my lord, we are all directed to produce the record.
Now, if they produce the report, so what benefit do we have?
Ignoring the Assamese, my lord, as language teacher, English teacher has been published, like, showing that language teacher. And one junior teacher has also been published. Although in the dice code, all have been categorized in the same level.
Yes, sir.
Section 14 of
Yes.
so that was affair under the High Court. Notification past order, staying the order of provincialization of the private respondent. And that was referred in appeal against that order. Appellate court also appealed the order. That is the appellate court's order.
committee has not recommended. So they prefer every before election.
Then he has no case at all. Even not for to go to tribunal, he is not recommended. Because this simply wastage of time. If the case is still.
This was your case.
Like, I don't know what is the order in this case. Here, Lordship.
Read it.
Lordship can see the order for a power by from 23 5
That I've read.
The last paragraph.
Hmm.
The respondent to produce the record of the legislation order to enable the court to examine as to whether the proper exercise under such and such that options was paid or not.
No, what difference it would make? You have not been recommended by the district scrutiny committee, isn't it?
Recommendation was there, but my name has been shown as Assamese language not recommended.
So you file an
Under the
appeal.
act, my lord, Assamese compulsory.
Prefer an appeal.
Assamese is compulsory. So
Who is that act?
English has been treated as language.
Education manual.
The Assam Education Provincial Services.
This one.
2017. Page number.
English has been shown as language disability.
Page number 99 below, it starts from page 99. And regarding the language part, my lord, maybe please to find section 3111 and page 111. Three teachers has been recommended. In case of Bhansar upper primary.
Section?
111 of this book. Page number. Section 31, Romans 11.
Yes.
In case of Bhansar upper primary school, there shall be minimum 3 teachers or tutors, at least 1 teacher each for science and mathematics, social studies, and C language as well. Now, my respected senior friends, contention is that English is not a language. Now we are communicating in the English language. Language is a mode of instruction for understanding of that. And English is also a core subject. It cannot be without drop from. It cannot be treated as an optional.
The act, my lord, one science teacher, one social teacher, and one language teacher. In Assam, my lord, Assamese is language teacher. And in the constitution, my lord, English is not a language.
See, district scrutiny committee has not recommended your case, isn't it? Now, when it is not recommended, where should he go now?
He should go to the appellate under section 14.
Section 14 says,
My lord.
against any recommendation of district scrutiny
Yes,
committee.
19, section 19. 92.
So it will be the educational tribunal.
Yes. And all the district judges of Assam, that will be given the power of education. Section 14 also covers, part of the kindly have a moment below, the state level scrutiny committee shall be the appellate authority against any recommendation of the district scrutiny committee. Now, here is a case, he is challenging my recommendation that we have been recommended, he has not been recommended. So in that case, section 14 appellate authority can actually get it. My lord also in the earlier occasion has disposed of. I have not brought those similar orders.
Yeah, I'm disposing it of. Yeah, approach the state scrutiny committee. File an appeal. heard R. Ali, learned counsel for petitioner. Also heard Mr. P. N. Sharma, learned standing counsel, elementary education.
Question number 1, 2, 3, and 4.
For the respondents,
1, 2, 3, and 4.
one, two, three, and 4. How 5?
And
Mr. Bakulia, learned government advocate, appears for respond number 5.
I am not responding.
Mr. A. Buyan, learned counsel, appears for respond number 6. And Mr. M. Sheikh, learned counsel, appears for respond number 7. Stop. The 3 number Bandara MA Madrasa was established on 1/1/1986 and was given recognition on 14/12/2005. Stop. The school managing committee of the madrasa appointed the respond number 6 as the headmaster of the said madrasa by a resolution dated 11/11/1992. Stop. The respond number 6 joined as headmaster on 12/11/1992. Is that correct?
Yes, ma'am. Yes.
Stop.
Page 26 is always aside.
Petitioner was thereafter appointed as assistant teacher of the madrasa by a resolution dated 24/11/1992. To which post the petitioner joined on 25/11/1992. Stop. It is the case of the petitioner that the petitioner taught social studies, public environment science as main subject along with language subject. So, the Nepala, the respond number 7 was also appointed as assistant teacher by an order dated 1/1/1997 with language as the main subject. Stop. The respond number 6 oblique headmaster of the said madrasa submitted the particulars of the madrasa along with the teaching and non-teaching staffs of the madrasa before the district scrutiny committee to scrutinize the reports of our provincialization of services. Stop. The district scrutiny committee recommended the case of the respond number 6 and 7 as assistant teacher within bracket English and social science respectively for provincialization. And the name of the petitioner was placed under non-eligible category as assistant teacher within bracket Assamese. Stop. Being aggrieved for non-provincialization of his service, petitioner is before this court by way of the present petition. Para. Section 14 of the so-and-so Act of 2017 provides for an appeal before the state scrutiny committee from any recommendation before the state level scrutiny committee against any recommendation made by the district scrutiny committee. Stop. In that view of the matter, this writ petition is disposed of, directing the petitioner to file an appeal before the
State level committee or before the irrigation on time?
Before the state, before the state level scrutiny committee, within a period of 15 days with effect from today. Stop. Draft state level scrutiny committee shall examine the case of the petitioner after giving a personal hearing to the petitioner as well as to the respondent number 6 and 7. Stop. And draft pass appropriate orders in accordance with law. Within a period of 2 months from the date of receipt of the appeal filed by the petitioner. With the aforesaid observations and directions, writ petitions disposed of, interim order passed and stands vacated. In terms of IA, in view of the order passed today in the main writ petition, IA stands disposed of.
So,
Come back to exhibition. Yes, please. Yes.
And the section travel while working as a teacher in Karuapara Government English School, died in harness on 25/2/2012. And my lord, moreover, this is the third round of litigation by the petitioner. And on earlier occasion, my lord, this honorable court directed the respondent to place the petitioner's case before appropriate DLC. And page 28 is the ordinance. Relevant era is era 6.
Yes.
Rejection has been set aside, my lord, and DLC was directed to place the case of the petitioner. But till date, my lord, nothing has been done by the respondents.
Yes. Bhupali.
My lord, dispose of
You can take instructions and come back, then we'll dispose. You have good time? Head case of Badal and the council for petitioner. Mr. Bhuvalia and the government applicant shall receive instructions. Please the matter again on 1 week time. 22nd February.
the
Yes. So in the last occasion, you were directed to produce all relevant documents that you have submitted before the Deputy Inspector of Schools, Hailakandi.
As for my instruction, I received instruction from the department where what are the documents that which is has submitted to the department. That next time we certificate is not here in that document.
The same instruction is to come to us. These are
the documents he has already.
My petition is pending. Yeah. Yes.
That's why, since you have not submitted your next of kin certificate, they cannot consider your case.
I did.
1 minute.
Also, particular fact, I received this document, this instruction from the limited. Yes, one is.
Obey, yeah. Technical defect. Technical, nobody can. Right.
You submit your next of kin certificate.
But I submit
When?
in my petition also. Yeah. 19. In 1920. Also, I obtained it 5/6/2009. Report. Why not I submit? Given by this year.
He has submitted block elementary.
So. According to my report, also, can you tell me that how many sort of documents he has participated?
No, block elementary officer, he has submitted before the block elementary officer. We don't know, there is a matter that is between the block elementary education officer and the district elementary education officer.
This certificate, my lord, placement is addressed to the block elementary officer.
Yes.
Directly.
No.
And something certificate format is not like this.
There is a prescribed format of extra certificate which is issued to the applicant, not to the operator. There is a prescribed certificate.
No,
Is this not the prescribed certificate, page 20?
this is not in format.
Yes, communicated to the block elementary officer.
This is not certificate.
This is the report.
Next to page certificate is issued by the department.
Other cases also, we have placed it to the officer. The format of the next application.
It may be very district.
No, it cannot vary.
Issued by
You submit your next of kin certificate. After that, they will consider your matter. Where is your submission?
My case is pending in 2022.
Page 22, read it. Last paragraph, you read page 22.
From this order, I yes.
So you submit your next
I
of kin.
submitted.
When did you submit it?
Minus 2012, Lordship. My
Where is the minus of 2012?
Even this, page 19 also, there are number of persons. After serial number 8, there is the signature of the reported in the signature of the deputy commissioner. Again, there are after 9, 10, 11, 12, subsequent to the signature.
pending.
I want to just give a loss.
That's why it's pending.
Pending.
It's pending because you have not submitted your next of kin certificate.
There is no adequate course. That's why 33 candidates are pending.
No.
The report was. The report. Addressed to the block elementary officer with reference to the.
Your case was considered on 5/10/2021 by the district level committee. There they found out that you have not submitted your next of kin certificate.
Why not they agree?
Why they should agree when you have not submitted?
Next of kin
You submit your next of kin certificate
the department.
and let the district level committee consider a matter again. I'll give you a direction to submit your next of kin certificate. After that, let the district level scrutiny consider your matter. When can you submit? You consider after that. Heard Mr. H. Alamgir, Learned Counsel for Petitioner. Also heard Mr. B.N. Sharma, Learned Standing Counsel. Elementary education for the respondents. 1, 2, and 4. And Mr. Bugalil and Governor Advocate for the respondents. The father of the petitioner, while serving as Jogidar in Janamangal Senior Basic School, District Hailakandi, died in harness on 17/2/2009. Stop. Thereafter, petitioner filed an application praying for appointment on commissioner grounds. When did you file it? Within the specified period. Stop. The grievance of the petitioner is that his case is yet to be considered by the district level committee till date. Stop. In the writ petition, petitioner has annexed an order dated 11th October 2021 as Annexure E. Order dated issued by the Deputy Commissioner and Chairman District Level Committee Hailakandi as Annexure E, wherein it is stated that the district level committee scrutinized the documents of the petitioner in its meeting held on 5/10/2021. However, as the petitioner has not submitted his next of kin certificate, his case was found not fit for recommendation to the state level committee. Stop. According to New Para, petitioner is directed to submit his next of kin certificate in the prescribed format before the concerned authorities within a period of 1 week, within a period of 2 weeks, with effect from today. Stop. Thereafter, on submission of the next of kin certificate by the petitioner, his case shall be placed before the district level committee, who in turn shall consider the case of the petitioner for appointment on constitutional grounds, strictly in accordance with law. With the above revisions and directions, writ petition is disposed.
For
The petition is pertaining to regularize the status of the petition. What happened in this case, Your Worship? The school management committee of Ekamani School, by taking a resolution, appointed the petitioner as honorary Chokidar from 2/1/2017, Your Worship. And since then, the petitioner has been serving as Chokidar in the same school, again the vacant school, without any break, Your Worship. And in the matter, Your Worship, the petitioner has accused the authorities to regularize the service, but the respondent authority has not taken a step, Your Worship. Your Worship, similarly situated for another person, Your Worship, by way of filing a petition, Your Worship. And this one was pleased to dispose of that petition by order dated 21/11/2021, which is annexed as annexed 5, Your Worship. Here in this case, the petitioner is seeking the similar relief. The operative part of that particular order is at page 23, Your Worship. last year.
Yes, Google.
If you have to, so for the present, it's concerned, he was appointed against in 2017. When the school says, well, the department has to work for 10 years. This is the of passing of the service. So he was appointed in 2017. But we might have said 10 years in the of passing of one year. So in both cases, where it doesn't come. And he is a honorary worker, it's not a contractual or master. Voluntary worker. Regular might not.
These facts and circumstances of this particular case, in this case, is different.
Definitely different as because here the petitioner has served only 5 years. But in the meantime, what happened in Oxygen, the state authorities have already initiated the process to regularize the grade 4 employees, your lordship. And online application has already been submitted by the petitioner also, your lordship. But the matter is that your lordship, already the petitioner has served for last 5 years without any penny of single penny, your lordship. So taking into consideration the service which has rendered by the petitioner, your lordship, while regularizing the post of grade 4, the petitioner may be given the difference, your lordship, against the vacant post in which he
We
is.
can't give you a preference. Yeah, Google.
If there is a vacancy, then you fill up by advertisement, not by some regulation.
But whether the petitioner is now overaged or not.
He is 34 years as per the rules.
Then
Then you have participate.
He has already participated, your lordship. Already participated. And
in the advertisement,
yes, your lordship.
was the advertisement floated?
Yes, your lordship. I have annexed the advertisement, the application form, your lordship, in the petition, your lordship. That is the page 20, your lordship. Annex of 4. And there is only the interview process is left out, your lordship. So,
This is a recruitment process. What does matter is around code cannot have a direct authority, even preference to particular matter. So previously, online application form for recruitment of this.
Then
already 5 years, the petitioner has served the
Open selection.
The hope that you will be regular.
you are,
Only
you have applied
yes, your lordship.
against an advertisement for grade 4 post. And that process of recruitment is still on.
Yes, your lordship.
Now, what do you want from this court?
Your lordship, only the protection I am seeking here. in this
What
case,
type of protection can I give you?
that I have served only 5 years. Your lordship. That may be
Maybe there
considered-
are other candidates also who must have served. Why should I give you a particular special treatment? You participate in the
the
interview,
hope that your lordship, the petitioner
with the outcome, await the outcome of the interview process.
At least the representation which has been submitted by the petitioner, that may be considered your record. As observation has been.
I'm dismissing your writ petition.
That may be allowed to issue the instruction or take instruction. to my
No,
client
no.
whether he-
What instruction do you
Your
want?
lordship, he has filed some representation that is not annexed in the petition, your lordship.
Then you withdraw and file afresh if you want to
No,
do it.
previously page 15. In the resolution for appointment, it has been stated by the committee that he cannot claim for regulation. Voluntarily, he has applied. Page 15. Resolution number 2.
No doubt he is voluntarily serving, but with the hope that he will be regularized. 5 years he has served, your lordship.
The resolution was passed by your school with a certain condition. You accepted that resolution and you are serving as an honorary.
Your lordship, I will be allowed to go with the, to seek the instruction from the client, when he has filed the representation. And with the liberty to file a fresh with the representation.
Mr.
I.S.
Huh?
I.H.
I.S. Laskar and a counsel for petitioner. Press for withdrawal of this writ petition with liberty to file afresh. Mr. B. Gobert, Learner Standing Counsel, Finance Department, appears on behalf of the respond number 2. And Mr. B. N. Gobert, Learner Standing Counsel. Education, elementary education, appears for respondent.
And five.
1, 3, and 5.
5 and 6.
1, 3, 5, and 6. And Didi Barman, then government advocate. For response number 4. With petition is accordingly dismissed on withdraw with liberty as paid.
I
Hmm.
the last point was used to the foundation of the government.
Hmm.
Consider of the petitioner was rejected on the ground that she was underage. The father of the petitioner was died on 2016. Accordingly, she has applied for the compulsory requirement on 9/9/2016. And admittedly, her age was below 18 years.
Hmm.
And after becoming major year, after becoming major, she applied on 2/1/2019.
Then
And considered on 5/1, 5/11/2021,
510.
5/10.
Then your case was rejected.
Okay, sir. Interim order is on page 68. That's the whereas after thorough scrutiny, the application submitted because of that the applicant was underage at the time of submission of the application. Her age was at the time of submission of the application 14 years, 2 months, 11 days. Lordship, similarly situated person rejected from the same ground by same deals on the same day were allowed to. This honorable court has reminded them to reconsider.
Yes, Gopal. Hmm.
Payment become a major after a number of years.
What happens to page 70 of the writ petition?
70. Yes, ma'am.
When was your case considered? 2021.
21.
By then the petitioner was a major.
Yes, sir.
Then
And even after becoming major, she has filed a fresh application on 2/1/2019.
Now these measure what? These measure.
we reconsider again.
Procedure you want to-
Third Mr.
R.M. Gupta.
R.M. Majumdar, then the counsel for petitioner. Also heard Mr. B.N. Goswami, Mr. B.N. Sharma, then standing counsel, elementary education. For respondents, 1, 2, and 4. Four. 1, 2, and 4, Mr. Bogali and government advocate. For respondents, 3 and 5.
Yes, ma'am.
3 and 5. So, the father of the petitioner, while serving as assistant teacher in 56 number Dikar Jasnabad LP School, Hailangan, died in harness on 23/2016. Stop. Drafted. Petitioner made an application on 9/9/2016 for appointment on conditional ground. Stop. On the date the petitioner made her application, i.e. 9/9/2016, she was 16 years, 4 months, and 23 days. oblique a minor.
I have got 16 years. As per Deputy Commissioner, Vijay Kumar, 14 years, 2 months, 11 days. Yes, 68.
Was 14 years, 2 months, and 11 days. And accordingly, she was a minor then. Stop. After attaining the age of majority, the petitioner made another application on 2/1/2019 for appointment on commissioner grounds. The district level scrutiny, district level committee, Hailakandi, in its meeting held on 5/10/2021, rejected the case of the petitioner on the ground that the petitioner was underage at the time of submission of application. Stop. But this court has already taken note of the fact that when the application was made by the petitioner on 9/9/2016, the same was not placed before the district level committee. Stop. When the district level committee considered the case of the petitioner on 5/10/2021, she was already a major. Stop. This court has already held that application for commissioner appointment is not an application for regular appointment, and therefore process of regular recruitment procedure would not be applicable. I.e., that the eligibility criteria would not be considered only from the date on which the application has been made. Stop. But considering the matter, considering the facts and circumstances of the present case, rejection of the claim of the petitioner for appointment on commissioner grounds by the district level committee, Hailakandi, on 5/10/2021 is accordingly set aside insofar as the petitioner is concerned, and the matter is remanded back to the district level committee, Hailakandi, to give a fresh consideration on the application of the petitioner for commissioner appointment on its own merits and in accordance with law. Stop. The application of the petitioner be placed before the next immediate sitting of the concerned district level committee. With petition is accordingly disposed of in terms of the above observations and directions.
6. The petitioner applied for the addition of such members of the September 20.
Chaudhary, you have filed your affidavit?
Fine, I'm a long time back. In fact, on the last occasion, I was told to get fresh instruction on the matter. Which I found. All the matters in the district, the verification of districts and all that. That was the come to class 6. This is a student of class 9. But this, the system which is being followed is the same as pertaining to both the class 6 and the class 9, which has been clarified in this instruction which I just pictured. Second paragraph.
Yes.
Therefore, although the student had qualified in the tentative merit list which is brought out, unfortunate as it is, he did not belong to the same district, and so therefore his candidature was rejected.
Who is that criteria?
What is-
Has he-
25 my petition
Yes.
says 25. 8.0 my eligibility. Only those candidates who are studying class 8 during the academic session 21, 2021, 22 is one of the top recognized schools of the district where the Jawaharlal Navoday Vidyalaya is functioning and where admission is so eligible. But where are the institutions are studying the rural district major, Boraimali, which is under rural district company, under the jurisdiction of the Navoday school.
Hmm.
That's the guideline is clearly stated. I have also stated in the paragraph 4 manner, my petition. And where the petitioner basically said that he was born at Guwahati district, which is his permanent address, where his parents have been living till death along with another family member, but the petitioner due to his study used to live with his maternal uncle at village Boraimali, Tuttapara, under custody years and years, Paigam, in the district of Kamrup, Dumre, Assam. He was studying class 8 at Adarso Oppam Jatiya Vidyalaya, Boraimali, during the academic season 2021-22 and accordingly, he being from rural area is issued with the rural area certificate by the concerned certain officer or other regional certificate, which is Alexa 2 matter. Therefore, this is the certificate. Page 16.
Hmm. Yes.
The advertisement manual. Alexa 3. Candidate is studying what is the idea number? Candidate studying in the class 8 in the academic session 2021-22 in some in the guideline matter, which is last academic session, he is studying under the jurisdiction matter, is eligible as per the guideline. That is the last.
Yes, so Chaudhary, I think there's some,
Of the recorded kind of submit is absolutely correct, and the guidelines do not specifically say. So far as class 9 is concerned, the guidelines do not say that
Class
there has to be
9.
the district clarification that is not mentioned in the guidelines. However, unfortunately, I cannot say that on record. On record, you also I kindly note my submission that this is the instruction which I am using. And also pass for this report.
it says that he should have passed class 8.
Yes, from a government recognized school, which is actually eligible. That's what I'm saying of the record. But like I said, I do not want to make that my
Yeah.
submission.
I know.
Lawful kindly note my submission and accordingly pass relevant orders. I have to respond. That clause 8 is very specifically saying that if you pass it from a government recognized school of the district, where the JNB is functioning and their admission is stopped.
Where is that?
Page number 25 at clause 8, Your Lordship.
8.2.
8.1. He actually fulfills both the criteria. He has studied in a government recognized school of the district where the JNB is located, and he is also sitting in the same district. So in these particular guidelines, there is no bifurcation thing, which was in the classic thing. The guidelines were little different. Although the authorities are maintaining their stand that they are asking for this from the same district, which I've just placed before your instruction.
No, he has also passed from the same district. Same.
But his documents are, when the verification was done, all his documents pertain to the district, except for this rural certificate which he has given and the school passing certificate. Except for that, the Aadhaar card of the parents and everything which they had asked for, everything is from the district. So that is the reason for his rejection. That was it.
You heard M.S. Ansari, learned counsel for petitioner. Also heard M.S. R.S. Chowdhury, learned standing counsel, JNV,
NVS.
NVS.
Parent for respondent number 2, 3, and 4.
2, 3, and 4. Anybody for Union of India?
Congress party.
For the respondents, 2, 3, and 4. Stop. The petitioner, no. The petitioner is the natural card of his son, Arfan Azam, age about 14 years, and who is seeking admission in class 9 of Jawahar Navodaya Vidyalaya Kamrup Rangia. Stop. Pursuant to an advertisement, this is dated for application for admission against vacant seats in class 9 within bracket 2022-2023. The son of the petitioner applied for admission in class 9 under the Jawahar JNV Kamrup Rangia. Stop. Then you were selected, isn't it?
Yes, he was selected.
The petitioner
621 selected.
was selected for admission in class 9 session 2022, and his name appeared under rural unreserved seats at serial number 2, bearing roll number 110667. Correct? Stop. During the course of scrutiny of papers of the petitioner, the concerned JNVS found the petitioner found the son of the petitioner not eligible, and his case was rejected for admission under the JNVS Kamrup Rangia, and therefore being aggrieved, petitioner is before this court. Para.
In my written statement, in my affidavit, Your Lordship, at paragraph 6, page 57, running page 57, Your Lordship.
The respondents have filed counter affidavit. Page
57, paragraph 6.
and there it is stated that the son of the petitioner was born in Dhubri district and his parents are still residing in the same district. Stop. However, as the petitioner, as the son of the petitioner,
So, what's the petition?
No.
petitioner is represented by his father. Son of the petitioner used to live with his maternal uncle at Goriomari, which is in the district of Kamruk within bracket rural, Assam. And as his birth certificate also shows that the permanent address of the parents of the permanent address of the petitioner is Dupri. The son of the petitioner's case was rejected with regard to the residential status, as he did not belong to the same district where the JNV is located, i.e. JNV, Rania. Stop. Para. The eligibility criteria for admission to JNV is indicated as, this is what?
It was page 85.
What is this 8.0?
This is the instructions, which were prospectus from application.
Instruction number 8,
Uh,
which provides for eligibility,
8.1.
and the relevant portion is extracted here and below. Stop. You say page A to A. 8.2 is also relevant.
But its academic session, there's no dispute that he has started in the academic session from 21 to
Yes. Page A to A, page 25. Okay. Stop. Para. Where was that certificate? Yes. This court has also considered
A2, annexure A2,
The-
page 16.
rural certificate issued to the son of the petitioner, namely Arfan Azam, isn't it? By the circle officer, Goriomari Revenue Circle, which indicates that the son of the petitioner studied in class 8 in Adarsha Ahom Jatiya Vidyalaya Goriomari, block Chayagaon, which belongs to the rural district of Kamruk State, Assam. A perusal of the eligibility criteria provided by the NVS for admission to class 9 during 2023 against vacancies, and clearly indicates that a candidate should be studying in class 8 during the academic session 2021-2022 in one of the government recognized schools of the district where the Jawahar Navodaya Vidyalaya is functioning and where admission is sought. Stop. Para. The rural certificate issued by the circle officer, Goriomari Revenue Circle, clearly indicates that the petitioner's son was studying in class 8 in Adarsha so-and-so school, which is located in the rural area of district Kamruk. A perusal of the eligibility criteria and the rural certificate issued by the circle officer, Goriomari Revenue Circle, would clearly indicate that the petitioner's son was studying in a government recognized school in the district where the present JNV is functioning, and the petitioner has sought admission in the said JNV. Therefore, this court is of the considered opinion that grave injustice has been caused to the son of the petitioner by denying him admission to class 9 for the session 2022. I think it's 2022.
22, page 28, 17.
For the session 2022-2023. Stop. Accordingly, the authorities of the concerned JNV is directed to admit the son of the petitioner, namely Arfam Azam, to class 9 for the session 2022-2023 in the Jawa JNV Rangya. When can you do it?
One small thing, is the instructions, latest instructions. Instruction can be taken out of that also while within my submission. Instruction also can be moved 1 to 20.
Within the period of how much? 1 week?
10 days.
Within the period of 2 weeks from the date of receipt of the copy of the order of this court. With the aforesaid observation directions, which petition is allowed, no post. Where I said about her submission, learned standing counsel NVS has also furnished instructions received by her
Dated 1 to
dated 1 to 2023,
paragraph 2 will be quoted.
which and the relevant portion which is under B to B. This one. I'm clicking it. Yes. But Mr. Enhak, let me concentrate. So, on request made by Ms. D.D. Barman, the government. 1 week at the time is allowed to receive instructions. Please the matter again on 15th February.
This application in time, but it is a remain unattended up to 2021. The case has been placed before the DLC version, that is on 11 to 2022 version, and recommended by the DLC. That is SLC version, which is handled 26 to 2022 version, as a rejected on the ground there version. The petitioner was a minor submitting an application version. But that's by considering application by the DLC.
Number 21. Date of birth will be 25 to 2007 and date of application 7 to 2022.
No.
Date of application.
Date of application is 7/8/2005.
Yes. Next page, next catalog. After page 16. The right recommended by the DLC version. That page 18. All done.
Here it is 7/8/2005 was the most significant month in 19 months. In this number, this 30 months, and it's 30 months.
Page.
And it's 30 months, and we have application months. This 30 months. no, returning authority.
That's not the issue of the present hearing. The issue is that it was minor at the time of the submission of the application.
The district level committee recommended the case of the petitioner
Yes, sir.
in its meeting.
Without that, there is nothing, Lord, the local committee recommended, Lord.
It is there. It indicates that they had gone through the application, which was filed on 7/8/2005. Otherwise, the district level committee would have rejected the case of the petitioner. It was filed only in the year 2022. This was the first time your case was considered in 2022.
Remain unattended, almost 15, 16 years.
Yes.
In terms of the fundamental effects to the terms of the initial articles. But it's not about the effects of
No. Bhavan, you have to understand one thing. He made his application in the year 2005. You did not attend to his application. And you considered only in the year 2022. By then the petitioner had already attained majority. And therefore the SLC and therefore DLC recommended the case of the petitioner. SLC on some other grounds rejected the case of the petitioner. But when now for 20 years, when you did not consider the case of the petitioner, can you attribute the delay to the petitioner or to yourself? Heard Mr. DK Google, the counsel for petitioner. Also heard Mr. Ben Sharma, you're there? Ben Sharma, the standing counsel, elementary education for respondents. 1, 2, 4, and 5. NMS. NMS. Yes. State level committee, if not met the party. By hand, how can I allow you? I'm already going to dispose it of. If you want an adjournment, file an IA, that is a different thing. On request made by Mr. DK Google, let me consider. List the matter on 15th February.
9.
Yeah, go on. After some time.
And
But no promotion has been given, so for your license. He has already completed about 30 years of service as a fully eligible for promotion.
but in this way, the instruction is required.
District around education period, separate department, only the PSC.
That's why I kindly pay you the order that is 16/11/2022.
I've seen. I'll issue notice. Affidavit is required. Third MS,
P1.
E. Burman, learned counsel for the petition. Issue notice. Mr. U. Sharma, learned standing counsel, secondary education. Appears for respondent number 120. Appears for all the respondents. Stop. Notice on respondents are complete. However, extra copies of the petition.
One intent that attendance case may not be filed for.
The respondents are allowed to file counter affidavit. List the letter after 4 weeks. Pendency of this petition shall not be above to the respondents to consider the case.
Well,
Yeah. Who? Nayak. Who is Nayak?
Get the case. That's all.
Okay, whose similar method, just now has been disposed of by other persons who go and put number 19. Those two cases have been dismissed. This is a component. So one
But Mr. B. Sinha, learned counsel for petition. On request made by B. Nayak, learned standing counsel, SSA. List the matter again on 15th February. Right.
13.
Changed the direction of the inter-construction. Question we kindly see page 14. The extra. Question. This is the position Russian. Question we kindly see. He was the earlier at Venture Street manner. First manner Abdul Hussain Mandal, headmaster manner. Next question serial number 3, Muhammad Saidul Islam. He was a teacher manner. And he is junior of this petitioner. So what happened? Can you see page 21? This school was amalgamated, and accordingly, it was attested to the basic school, and this order lost will find page 21. But respondent number 5 and petitioner from the same. So he is junior to me. But this order, by speaking order, I have been appointed as interim administrator of the basic school matter, that is Rasul Finance order last. Abdul Hussain Mandal, headmaster of the Narayana Navadvip MEF, is hereby allowed to hold the charge of interim headmaster along with the delegation of financial power of Central School with immediate effect until further order. Next question, the Kalisita in one piece. So page 21, next of 4. The order issued by this office memo number so is hereby kept in abeyance until further order. So just after 2 days, thereafter lost in the currency, page 23. This is a direction to hand over the chart matter. So there is a direction I have not been hand over the chart to this matter. I will allow you to do that. It refers to something second airport on 19/7/2022. This date may be noted. It's before the passing of the order of the amalgamation. So this office by number so Muhammad Saidul Islam was allowed to act as interim headmaster. So So you are supposed to hand over all the charges, including all documents to Saidul Islam Management. Because this already is without any manner hearing or any opportunity given.
Yes, who appears?
I have delivered yesterday. I have not been hand over charges.
But Mr.
G.
You didn't know the council for petition. Issue notice. DN Sharma notice. Standing council. Elementary education appears for respondents 1, 2, 3, and 4. Extra copies. Furnish. Petitioner will take steps for service of notice or respond on the file by registered post ID within 1 week. Respondents are of the file for draft visits. List the matter of the 4 weeks. In the meantime, status quo as on today shall be maintained till the next return.
Fifteen. Fifteen.
None appears for the petition. List again after 1 week.
16.
There, my lord, the petitioner and the student of Chalmers College. And there, even has been resolved, that is, my lord, impunity, page 37. Without contacting the hearing, my lord, and without any condition, and saying that the violation of the union has been resolved. Eventually, my lord, the principal of the college has collected some illegal fish in the COVID-19 in the name of Santa Fish. And therefore, Lordship, one FIR already been lost from the side of the student union. That is, Lordship, I have to page 20. And that has been registered against the principal under section Lordship 412 and 409.
Where?
Page 20. And the student by agreed because during the COVID-19, the student union from the student and which has been collected, where examination was conducted on that. And therefore, this FIR was lost. And FIR already been registered. Now the investigation is going on. Thereafter, Lordship, the student also approached before the Deputy Commissioner, Dorong Melot, on 19/12/2020. That is case 29. That has been received also. I received number 6427. Case Lordship 29. And here was the allegation against the principal because but student development fund has been too high. That has not been released. And legal student examination center which has been done. And that has yet not been refunded. And this is the allegation, my lord, and therefore the petitioner also approached before the president of the governing body, that is case 33, with regard of the same allegation. These are the this already representation has the actual disposal. And in the meantime, this impugn notice has been issued. This is the case. Because as per what university guideline and direction during COVID-19, when examination was conducted through online, the exam center which has not been connected in other countries. But whereas in this college, the examination center which has been connected, that has to be refunded. That's this is like this.
Yes.
I agree. I from the the regional issue, like this, and it's on. This is a service would be.
Yes.
Because right of the student in India has been affected for three parties. Undoubtedly, there are rights and three parties. And student union as well as the whole student has been deprived because of illegal collection in the name of center doing the online. So we end it. Go and
Regarding the maintainability, one issue that is there. Second one is you're not challenging the notice, isn't it? No, you are not challenging the notice. You are challenging the resolution content in the notice.
so far my clear is concerned.
Read your prayer.
The release of the student union development part for the session 21-22 and 26 lakhs. And my lord, refund the illegal fees to 32,000 members of the student. My lord. And my first pair set aside the income decision that is 21st 12, 2022. This is also
Read it properly. Read it properly.
there, my lord, number one, to set aside the income decision 21st 12, 2022. By resolution number one.
1 minute. That is the resolution
Yes, in the impugned notice.
appearing in the impugned notice. Appearing in the impugned notice. You are not impugning the notice. You are impugning the resolution appearing in the notice.
So far the notice is effective because the impugned resolution has not been finalized because the notice already been passed.
Read it properly. If I'm wrong in my English, or
Notice, my lord.
yes.
It is hereby notified of all concerned. that
No,
has
no.
found-
Read your prayer.
Next prayer, my lord, to release the student union.
No. One.
To set aside the impugned decision dated 21st 12, 2022. I resolution number one appeared in the impugned notice dated 22nd 12, 2022.
To set aside the resolution on it.
Because the notice, the sole part is the resolution. And
So-
because notice saying that regarding the resolution, they adopted the resolution that appeared in the notice.
So you're
And
not.
this is why not impugned. So what annexure 6 is the impugned.
So you're not impugning the notice. You're impugning the resolution in content in the notice. Correct? So I can't issue an interim order also. I can't stay your notice when that notice is not under challenge. I don't know if I can issue notice in this type of a writ petition. You'll have to satisfy this court.
Because so far other part is concerned.
No. You'll have to satisfy this court now for issuance of notice.
So I am on this representation, my lord, page 20. This represents on the basis of this repetition, this my representation. The deed is mentioned because this was addressed to the Deputy Commissioner, and that has been received on 19/12/20. And that is the receipt number also shown. But that
Yes,
has not been disclosed.
what you-
Rejection will be given. Make a inquiry. So far the representation is concerned. I am on this case. And so far representation is concerned, that has not been disposed of. So rejection will be given to that to conduct it. Because it is related to the student union and as a whole, the whole student.
You file an affidavit on the maintainability of writ petition. Yes.
I'm looking for one of them, started the school college of.
Okay. But Mr.
That's me.
S. Buya, then the council for petition. No. You're good. Third, Mr. K. Boyan, then the council for petition. Mr. S. Issue notice. Mr. S. Buyan, Leonard, standing council.
I will.
Higher
One.
education affairs for response number 1.
One.
And Mr. Sensu, Leonard, standing council, Bharati University affairs for response number 2. MSD Burman, Leonard, government advocate affairs for response number 3. Petitioner to take steps for service of notice on respondents 4 and 5 by registered post AD within 1 week. The issue of maintainability raised by the learned councils for the official respondents is kept open. Stop. List the matter of 4 weeks.
Hello. 70.
Use your mic. Your mic on. Yes.
School managing committee lordship, the by the proposal has directed proposed to hand over the land to the petitioner. According to approval from the DU. The DU is hesitant to allow the proposal lordship. He said that to take an order, I have already not over to.
Why should we keep on issuing orders? Where is the order?
Proposal lordship.
Yes.
Proposal number 3.
Yes. Then where? Then yes.
Page 9, madam. Yes. Limited period to directing the respondent number 5 to allow the petition of the claim its length on the issue managing body. This may go to the issue management.
No, your prayer is to claim your land from the school management committee. Has this proposal been sent to the DO? Then now how do we issue the notice? How do we issue direction? Now this is only a school management committee proposal. Now whether this proposal has been sent to the DO? How do we do that? What functions is whether the whether this proposal has been forwarded to the BO. To the BO, has it been forwarded? Where is it? Where's the forwarding letter? Where is that? How do we know that this has been forwarded? All that I have is a proposal of the school management committee only. This is only a proposal. Now after this proposal, it has to be forwarded to the BO. How do we know that it has been forwarded? Has the school management committee forwarded it to the PO? Then how? I have seen the resolution of the school management committee. Now whether this has been forwarded to the BO? You take instructions and come back. Or you file afresh annexing those proposals. The council for petitioner shall take instructions as to whether the proposal number 3 taken by the Dakhin Muirat Has LP School Managing Committee has been forwarded to the concerned block elementary education officer. Stop. List the matter again after 2 weeks.
18.
Start off on my other council, any council for state.
I know that how do you call a SA is required there? More of the elementary. Elementary. Minor executed, is it from the elementary education department?
Yes. Yes, yes. One of all the last days, the as responding the secretary personnel was also impeached with the party and notices are actually given to him. But that could not be done without the order of the so I will be about survey copy of the semi council of the personnel department. And they come after some time.
Okay. Mr. B.B. Chalian, then you are appealing for the personnel department?
Yes.
Then, yes?
There is no personnel. Secondary personnel.
You are appealing. Have you received copy?
I will submit.
Let the senior counsel for the petitioner is directed to furnish a copy of great petition to the Leonard's government to MS B. Barman and the government advocate who appears for the personnel department. Stop. List the matter again after 1 week. Registry is also directed to reflect the name of the Leonard government advocate in the process. After 2 weeks. Not 1 week, 2 weeks.
19.
Another thing is to the 3206. Authority other application has 2 applications. Those are provided by the concerned block official.
1 year. That has not been considered. And after that, by subsequently, that was also provided by the proposition. But it was not placed before the district official. So it is not to approach the director, and director has also placed the order. Several matters. To place the case of the petitioner before the DA. But it has not been placed.
Yes, Bhopale.
The matter here, to place before the PLC by the department.
Hmm?
The matter here to place before the PLC by the department. This department who places the proposal to the district level.
Have you placed it before the DLC? Your good time, please. Your good time. Heard Mr. B.K. Goswami and the counsel for petitioner. Also heard Mr. E. Dalapkar and the standing counsel. Elementary education for respondents, 1, 3 and 4, and Mr. Bokule, the government advocate for respondent number 2. Stop. Who is the petitioner here? The father of the petitioner, late Manishwar Kalita, while serving as headmaster of Barkatri Anchalik Girls ME School, District Nalbari, died in harness on 3/2/2006. Stop. The mother of the petitioner made an application in the year 2006, praying for appointment on compassionate grounds. Stop. As there was no response to her application, the mother of the petitioner again made you made the second application, mother made the second application, made another application. On 28 August 2007, praying for appointment. No, stop. There's no steps were taken. The mother of the petitioner approached the concerned block elementary education officer seeking information. Stop. Drafted. Her application was forwarded to the district elementary education officer by the block elementary education officer on 28 August 2007. Stop. As no further steps were taken, the petitioner, who is the daughter of the late Manishwar Kalita, made another application for appointment on compassionate grounds, which was forwarded by the block elementary education officer on 21/4/2015. Stop. As the case of the petitioner is yet to be placed before the concerned DLC till date, petitioner is before this court by way of the present. Para. Concerning the after hearing the learned counsel to the parties, this writ petition is disposed of, directing the concerned department to where
25.
That's why the concerned department is directed to place the case of the petition before the concerned district level committee in its next immediate sitting, if not already placed. Stop. With the above observations and directions, the petition.
Benji. It's a restaurant product that is washing fine at least 55. It's 55.
Yes, read it.
Order dated 17th October 2022. He can tell you order dated 22/12/2021. Also, he can tell you SB dated 14th August 2017 and petition dated 10/12/2021. Submitted to the officer. Whereas, once you are not finding case very and wants passed where the petition was appointed as subject to several but the school was the church state and his name is given the very distinct level is to be known as correct.
Yes, I'll issue notice.
Because the state government supposed to pass the order as per the order of the post order. Under section 14, your lordship here, the state government is given a complaint authority to pass an appropriate order in appeal by way under section 14.
Well,
This order has been issued by the director.
it says the state level scrutiny committee, isn't it? The order directed the state level scrutiny committee.
But the section 14, your lordship, can you see who is the complaint authority? The secretary is the complaint authority to pass an order, not the director.
Where is the order of the High Court?
Yes. I think order is also. Is
32.
32 and according to what I also to find at page 34. Paragraph 4.
Yes, it says state level scrutiny committee
Right.
under the Act of 2017 to give a consideration and bring the appeal to a logical conclusion.
Yes.
Now, who is the state level scrutiny committee?
Lord, the order has been issued by the Lord Joint Director, IC Director of Security in Assam. The committee is headed by the Lord.
Section 13, clause 10.
Clause 10, Your Honor. Director of the concerned department of education will be the chair.
There shall be on state level scrutiny committee at state level for benefit of the recommendation received from the district scrutiny board to the following members, namely Director of concerned department of education, Joint Director, Deputy Director of Education, on level scrutiny committee shall have the first physical verification of all institutions.
You are saying director don't have the authority.
My lord.
Director is the chairman of state level scrutiny committee.
Now, the administrative department, the secretary is the my lord competent authority.
No.
And that too, my lord, without having the my lord petitioner.
Against the state level scrutiny committee, the state government is the appellate authority.
Yes. And against the state level committee, my lord. My name was recommended by the district level committee.
You filed an appeal
My land appeal.
before the state level scrutiny committee,
Yes.
correct?
Before the government.
State level scrutiny committee against the decision of the district level committee,
My name was recommended by the district level committee.
correct?
It was neither rejected nor approved by the state level scrutiny committee. So I filed appeal before the secretary.
What does the judgment say? Read the judgment.
Now, what should I see my appeal before the Lord approved?
Forget your appeal. Read the judgment.
Right.
Read the judgment of this court.
Yes.
Para 4.
Correct. The limited grievance raised by the petitioner in this proceeding is that the file of such statutory appeal having been prepared by the petitioner, the authorities concerned have not taken consideration of the appeal as agreed in brief of the limited grievance raised to dispose of the petition directly to the state level scrutiny committee under section so and so to give a consideration and in the appeal of the petitioner under section 14 of the act dated 23, 25, 2020 and etc. level is so and so which was kept.
So direction was given to
Suspended the scrutiny committee.
drafter. This order was passed.
Yes,
This speaking order.
yes.
Who passed the speaking order? State level scrutiny committee.
Yes.
So director is the chairman of the state level.
Okay.
How do you say he does not have the authority?
Yes, now what shall I see my appeal?
Where is the appeal?
Page 31.
Yes.
Yes, it was addressed to the Commissioner Secretary, Dr. Basa. Now, 14 says, update authority the government.
Hmm.
So my submission, my lord, any order ought to have been passed by the my lord government.
Mr. Mondal,
Okay.
you are present on the day this court passed the order.
Right.
You are not aggrieved by this para 4?
Yes, that's it.
You are not aggrieved. Para 4, this court said state level scrutiny committee to
Yes.
pass an order.
Right.
State level scrutiny committee has passed the order.
Then in that case, my lord, we have to file again, my lord. We have to file appeal again the my lord government.
That's what-
That is so.
That's what I'm saying. So you file an appeal before the state government.
Yes, that is,
This writ petition, then nothing survives here.
that area is, yes.
So you withdraw and file
In that case,
before the
my lord,
state.
yes, in that case, my lord, lordship may observe, my lord, I file the appeal to the government against that order. Yes, I
So I'll
understand.
say, you got my point.
Yes,
That's what I'm saying.
yes.
Mr. M. E. Mondal and the counsel for petitioner submits that the petitioner may be permitted to file an appeal before the state government against the decision of the state level scrutiny committee dated
17 October.
17 October 2022. Recording the submission made by the learned counsel for the petition. This writ petition is accordingly disposed of, permitting the petition to file an appeal before the state government against the decision of the state level scrutiny committee as provided under section 14 of the so and so Act 2017.
Yes. 21.
Where? Yes.
Yes,
The order objective covers my case.
what is it?
My case is covered by this order objective.
Page 80. Yes, page 80 covers your case.
No wonder. Subsequent order is, I am taking your option. Page 63. From page 68 onwards, which I did this in that. This is the order of 30/11/22. And the earlier one, which my learned friend has referred to, it is of October, and this is of November. 11 portion you will also find at page 72 and 73 much. From paragraph 19, they kindly see matter. They read matter.
Yes,
The honorable court has held that since they are not going to discontinue the scheme, so the service may be continued. So, in my case also for same prayer. Scheme that we are working certificates I have annexed matter.
Whatever was total on that particular day, what will issue notice? So there is the based on that. The production of that.
yes,
The production of what will issue notice to pass on. Around.
this is also same thing, 21/10/2022. Or you want your case to be covered by the subsequent order?
Yes, sir.
Yes, Bora?
PR is something different than the, that's why. We are also to check, what is under the PR page number 24. And they include later dated 23/8/22.
This is the same equal letter.
That's why my lord, the order dated page number 63.
I'll just pass a short order saying that your case will be covered by this.
Yes, sir.
But Mr.
Yes, Ali.
S. Alim, then a counsel for petition. Also heard. Mr. P. Talukdar for response number 1. Learned Government Advocate for response number 1. No. Learned Standing Council Elementary Education for response number 1. And Mr. S. Bora, Learned Standing Council SSA for response number 2 and 3. Anybody for the Union of India? And MS? We got the council appearing on behalf of SK Media, then the CGC for the response number 4. Farah. Petitioners are education volunteers and additional education volunteers of different non-residential special training centers in Lakhimpur district. They are serving continuously for more than 15 years at a nominal fixed pay, and accordingly they submitted representations to the authorities in view of the judgment passed by this court, passed by the Honorable Division Bench of this court in writ April number 45/22/14, within brackets State of Assam versus Ubin Das and others. Stop. No, cancel it. Huh? They have served continuously for more than 15 years at a nominal fixed pay. Stop. Learned Counsel for Petitioners submits that the case of the present petitioners are squarely covered by the order dated 30/11/2022 passed by this court in WBC number 7001/2022. Stop. The same is not disputed by Mr. S. Bora, the Standing Council SSA, as well as Mr. P. Dalutta, the Government Advocate. According to former, it is directed that the case of the present petitioners shall be covered by the order 30/11/2022 passed by this court in WBC number 7001/2022. Stop. The respondents are directed to take steps and act according to the order dated 30/11/2022 passed in WBC number 7001/2022, insofar as the present petitioners are also concerned with the above observations and directions to the petition.
22. And 2 times a day. And it is for 1 year, 1 month is the Omar. So since already submitted the application as it is evident, there is a clause also in the advertisement regarding the relaxation of the.
Where is the advertisement?
The advertisement page starts from 32 months. And that the relevant clause is page 27. The advertisement applications are page 22. Applications are emitted from the eligibility and citizen difference also. 7,500 vacant posts of graduate teacher arts, graduate teacher science, graduate teacher Hindi, graduate teacher Sanskrit, etc.
What date is this application?
That question is page 27.
Yes, where's the date?
And relevant question. Page 27. That is another. Is not that is here.
Where? Yeah.
Page 25 of the notice. Page 25.
Yes.
Page 25, other criteria, accident number 2. Page 25, a candidate must not be less than 18 years of age and not more than 40 years of unreserved category, 42 years of ex-serviceman, 43 years of OBC and OBC, divisional is OBC, and 45 years SC, ST, so and so, and 50 years for partial disabled. Now, as January 22, as per the government of this memorandum dated so and so. Now, under this is now 44 years, 1 month, and she has submitted application also. Page 27, the relevant option. The page 27, F cross 7, that's the F. Please note, there is anything. The application seeking moderation, relaxation of any criteria should be made to the appropriate authority as per applicable norms at least 7 days prior to filing of the online application.
Have you made your application?
Yes, sir. It was 12/1.
When did you submit your application?
It was 12/1/20.
No.
Application for relaxation of age. This is submitted on 12/1/20.
Then
I have not annexed.
then
Along with the application, my lord, you will see may allow operating once in a minute. If I have this in terms of receive also.
There is no response on this letter. And moreover, my lord, in other crimes again, it is clearly mentioned that 43 years for OBC.
no, that I've seen. But for so far as the F is concerned, it says he or she has to make an application 7 days prior to filling up the online application.
Yes.
Have you filled up your online application also?
No, my lord, how can it pay? Because it will not accept, my lord. It's generally.
When is the date of this advertisement?
Advertisement date, my lord, 28/12/22. This all that process is going on.
28/12. When is the last date for filing your application?
My lord, there has not been mentioned, my lord, in the application.
No, there must be something.
That is not here in the application.
Yes, you shall. No, you just take some instructions and come back.
Yes,
Whether you have considered this application or not.
yes, my lord.
Part H does London Council for Petitioner. Stop.
And next,
I have the sample copy also, my lord.
You've got a copy.
yes, sir.
Mr. U. Sharma, London Standing Council, Higher Education,
Secondary education department.
Secondary Education shall receive instructions whether the concerned authority has taken any steps in terms of the application made by the petitioner on 12/1/2023 for condemnation of her age. Stop. How much time? Release the matter after 2 weeks.
Sir, interim, my lord, process must be not.
No entry.
23. Item 9.
Yes.
The case of petitioner initially appointed as tutor the Karutia College as lecturer. Case number 24 is the initial appointment.
Yeah.
On 29/11/2022. For that proof.
Yes.
Hereafter, Lordship, he was formally appointed in 2004 Lordship by way of advertisement of the college. That is case number, advertising case number 28, and appointment is case number 29, 2724.
Non-sanctioned post.
Page number 29. Is the appointment by way of advertisement, this formal appointment. Until date, he was serving as a lecturer of faculty. In the meantime, Lordship, what happened was each time the petitioner approached before the Son of Court for regularization of some current vacancy, Lordship, which was arose time to time. But the petitioner, although the 2020 court considered the case of the petitioner, but the opposite party, some of the other applicants, after advertisement, they challenge this court and their process is abandoned by this court. Therefore, Lordship, several times the petitioner failed to regularize his service. Although the court considered first time, but thereafter 2 times again filed Lordship. That process also the petitioner failed. Now the Lordship, I have just immediate prayer Lordship. In the page number 14, Lordship, kindly see page number 14. This is decision by the government Lordship. As per this decision is on the basis of 46 report of committee, Assam Legislative Assembly. This is the decision, and by this decision, the Higher Education Department decided to regularize the non-sanctioned teachers who were appointed before 12/10/2004. Kindly see the bottom last line. This is the decision.
Page 14.
Page 51. Another. This is the decision on the basis of Lordship 46 report of the Committee of Petition Assam Legislative Assembly. It is decided for the last paragraph Lordship. In view of the above fact, government is requested to kindly to take necessary action for creation of functional post of 107 number of assistant professor for regularization of service of college teacher working against non-sanctioned posts prior to 12/10/2004. Those service are to be regular. This is the cut-off date, and my appointment is before that. Lordship, in the meantime, Lordship, another litigation, last page kindly just for one moment, Lordship. Page number 63. Our last writ petition, Lordship, page number 63, Lordship. This case was dismissed because earlier cases are dismissed by this honorable court, and I have no right to regularize my court by way of adjustment. That part is here, and I have no claim on that. Since the court decided that I have no claim to regularize my service in the present vacancy or by way of adjustment, that part is here. And in this case, it is also clear that last paragraph. By this order of activity also clarify in page number 11. If the petitioner service is regularized by way of this decision Lordship, there is no bar.
Page.
Page number 69, Lordship, last portion of the order. Paragraph 11, Lordship.
Yes. So,
Lordship, nonetheless, the court extends to add that this order shall not stand in the way of the respondent authority to take a decision of the whether or not to regularize the service of the petitioner by creating personal code in terms of 46 report of the petition Assam Legislative Assembly, wherein the said committee has resolved to create personal code for regularization of 107 numbers of assistant professor working without valid post to take in appropriate decision there. So, although my petition is dismissed, but in case of this decision, there is no burden. Now, I have filed the application submitted application to enlist my name in this list, because my name is dropped from this list without any reason and maybe wrongly, because there is no doubt I am appointed before 4/10/2020. And kindly see the just one my application kindly.
Where's your application?
Page number 57. This is my application. Therefore, enlist my name in the petition committee list. Thereafter, my application was forwarded. Also, kindly see page number 58. My application was forwarded by the director to the Tharupetia College Principal for report whether I am appointed before 7/4/2020. Then all the reports submitted. There is also mentioned that I am appointed before the cut-off date also. This is the report also. Next is page number 59. Where it was mentioned that on the departmental prosecutor was appointed. The petitioner was appointed 3/7/2004. Here it is clarified. There is no doubt I am appointed before that. Hereafter, Lordship, after submitting the letter, the director of higher education forward my application to the secretary to the government of Assam Higher Education Department, and my case is pending there, Lordship, for final decision whether my name is included or not. In the meantime, Lordship, one list of published process is going on. I have another list of page number 56. 50 started from 55.
They must have taken some steps pursuant to this. Have you got any instruction?
Since in this case, Lordship, the recommendation made by the petition committee is rejected and negated by the cabinet of the Assam government. There is no case. The recommendation, Lordship, which was given by the petition committee to the Assam Legislative Assembly, the cabinet has already rejected their recommendation.
Yeah.
Let them file affidavit, Lordship. Yeah, honorable cabinet has rejected the recommendation of the legislative committee on the basis of the judgment passed by the full bench and division bench and single bench. Minor also passed order. All the orders placed before the cabinet, and after verifying this process, cabinet has rejected the claim of the recommendation of the petition committee.
You file your one line of work, Mr. A.U. Ahmed and the council of petition issue notice. Mr. G. Gopal. No, no. Nothing comes in higher education. Appears for responding on to petitioner to take steps for service of notice on respondent 3 and 4 by registered post within 1 week. List the matter of the folks. In the meantime, respondents may file their contract. This one motion. 23 is over. 44. Let's.
And 45.
Is this a motion matter?
Direction. State it remains, so it's a motion for non-fiction.
If records are to be produced, maybe notice should be better to issue notice, isn't it? That's why such matters can't be taken up in the motion stage.
let the record, I couldn't file our complaint, I am for the private response. We are defending that there is no case for injury water at this stage. Because, that is like this. I was appointed as the regular principal of the RCB school, way back in 1970, 2017. 2017, May 2017. That was put to challenge by my other friend's client, who was recommended in number 2. The colloquial bench of this honorable court, in that resolution, was my appointment and directed the authority to relook into and address the issues. Because it is that my client went to the appeal. This appeal court has set aside the judgment of the private citizen and demanded back the matter to hear it afresh. So it stands at the bottom stage. This is now to be heard from the beginning. Nothing remains there. And because that time activity was done by me also. That time it was also the different stage itself which was done. Therefore, court directed that you may meanwhile exchange your feelings. That's how I have filed my affidavit now. You may have also filed it by law, which is otherwise for anything, it can be heard now. So therefore, no hurdle at all. And the only order, legally valid order standing as on today, within the field, is my order of appointment as the regular principal of the school. 2570. The school is being run by inspector of schools, located at a distance of 19 kilometers. It doesn't run the school. And since 1996, there is no regular principal in this school. And it's a situation. The school is suffering greatly. Therefore, the authority now found that the order, which was initially issued 25/2017, appointing me, that is the valid order standing as of today, that should be given effect to. And let the cases be decided, and then when decision comes, they will be as per the order of the state. Therefore, the opinion of the Advocate General was also taken. Advocate General opined that there is no hurdle, there is no impediment for giving effect to that order of 2017. And therefore, the authority notified that this order should be even re-notified. The earlier order should be re-notified. And that order was issued by the Commissioner and Secretary. At page 71, got simplified. 25th November 2022. That was by the Secretary to the Government of Assam. Has issued this Education Department. Then it should be re-notified. Having considered all these decisions of this honorable court, this decision, then re-appeal, then the other decision which was filed by the all these will take into account. And therefore, the opinion was not from the Advocate opined that there is no difficulty. Then it was placed before the Advocate notified approval of that report also. It was done, and therefore, this order was issued that it should be notified. Accordingly, the director has on 13th of January 2023 issued this order that notifying that that order should come into play, and my client should be handed over the charges of the principal by the inspector of schools. And the inspector of schools has already handed over the sir. I am holding the office from 71. I am holding the office. Now the exams are coming. I am issuing now the admit cards. Higher secondary exam is coming off it now. From this month, itself. Therefore, at this stage, there is nothing. No step, nothing of this sort as on this. So, until and unless the cases are hard and decided, how can the authority be stopped from implementing the valid order which is standing as on today, March 25, 2017? That is my case. They want to say, they want to take the handle of one thing. my objection indicated that sometime in 2021, they issued a notice to me of fraud. Because certain allegations was brought against me by his friend. Because earlier, there were some allegations by the people when he was holding the cert, local people filed allegations against him. Therefore, he counter blast, he filed allegations against me. Those were inquired into, and the director whimsically issued a notice against me. So in court, I have given a so-called. Meanwhile, the secretariat was looking into the whole issue because of this tangle. They are saying, how can you do this when the government is looking into it? At any rate, the government has ultimately said we have done a higher inquiry. That inquiry was completed. And because meanwhile that should have noticed to me, the so-called. I have replied to him. More than a month, they are gone. They have not done anything. They are sitting. So proceeding as such, no inquiry, nothing of this sort. My reply got, they are keeping silent. And even if we take the worst case, if a proceeding is started today, I have been appointed in 2017. So when the departmental proceeding will be taken into a logical end, then only the authority can impose certain penalty on me, if at all they can satisfy the charges. But this initiation of any disciplinary proceeding subsequent to the point of my promotion cannot be a ground to put it at now, that it cannot be operated. That is my submission. Legally, it is not tenable. There is no legal foundation in this submission. Taking the worst case that the departmental proceeding is pending against me today, presuming that by itself will not be a ground to remove me from the post of principal, which I was appointed in 2007. Therefore, there is no case for stay. My learned friend may ask for early hearing. I have no objection to that. But meanwhile, let the presence be completed. If records are required, proximate definitely look into the records. But at this stage, I don't think there is any reasonable ground to ask for the records to be looked into, because that will be a futile exercise at this moment.
Yes, who appears secretary? Yes. We have the reports.
I know I have no record. So I will produce the record.
We'll issue notice.
May I make some submission? Initially, also, the appointment of separate learning symbols. Then there was a review selection. In the review selection, also the petitioners took part. Then also he made a false allegation against me. There are an inquiry. In the inquiry, also, there are allegation and counter allegation. In the inquiry, also, I was exonerated. Also, nothing was fine against me.
Who's holding the post now?
That is, I am coming to it. Now, in the name of the division back order, may kindly see at page 69. Last one.
Yes.
Only on one technical point of it, the largest in the order of the status, right? But at the same time, also may kindly see paragraph 9, page 69. Mr. Nair has made an attempt to assess the recommendations made in favor of the litigation. However, since the Lawrence Chinnikal has not decided the claims and counterclaims of the parties on merit, so as to decide the question of legality and validity of the selection process, insofar as the correctness of the assessment made by the selection of part, the contending parties is concerned, we do not deem it appropriate to go into those aspects of the matter for the first time in the appellate court. For the reasons stated above, we are of the opinion that the interim judgment order is unsustainable law. We accordingly say that the interim judgment order 28/2019 and remand the petition to be heard by the Lawrence Chinnikal based on merit. It is submitted at the bar that at present the inspector of schools is holding the charge of the principal of the school in question, and therefore there is an urgency in the matter. Since urgency has been expressed by both the sides requesting for an early hearing and disposal of the writ petition, we direct the registry to use the writ petition being doubled 268 of 2017 before a Lawrence single judge as part of roster on 17/6/2022 for us. In the meantime, the parties may extend pleadings facilitating early hearing and disposal of the writ petition. The parties are also granted liberty to make a request for expeditious hearing and disposal of the writ. So it was in agreement also the inspector who will hold the step. in the disposal of the bid petition, we had expressed. Now, Lordship may kindly get another aspect, Lordship may kindly find the inquiry to only one product.
It is submitted at the bar. And that the answer.
Yes,
Page 54. Page 61 of the relevant question, the type of the. Page 61. Conjugate upon the department proceeding has been initiated against Muktidas, with the responsible for of Raisangia High School Secondary School and the Nogan School based on the findings of inquiry report submitted by a group of officers, wherein few serious allegations have been leveled against Muktidas. Accordingly, departmental proceeding has been initiated by issuing focus notice to Sri Muktidas, resident teacher, Vati office, notice dated 129/6/2020. In view of the above facts, government is requested kindly to look into the matter and take necessary approval for appointment of the principal of Raisangia High School and the Nogan School on the recommendation of the special board. It was my recommendation, my name was recommended by the inquiry committee. That was if I can come to the, since the departmental proceeding is still pending. That is why Lordship with the honorable court on the last occasion has specifically asked for the particular record, wherein the departmental proceeding is pending.
that's why we'll call for the record. There's no harm. But we'll issue notice.
And since my stay order is also to be considered. Lordship.
I'll issue notice. Meantime, you exchange.
Kindly come to the only two particular record has been called for. Pertaining to the-
How can I dispose of this petition on or in the motion stage?
Then in that case, Lordship, my intent may be considered because the in terms of the division bench order, so the inspector was referred to.
I've read the division bench order. After reading that, I'm not inclined to pass any interim order today. Yeah, Mr. Heard SK Das level counsel for petition. Issue notice. Mr. U. Sharma, the standing counsel, Secretary Education, appears for respondents 1, 2, and 3. So notices of 4 is appearing. Mr. K.K. Manda, then CA counsel assisted by MS and Begum appears for respondent number 5. Notice and respondents are complete. Respondents are allowed to file the respective counter affidavits. Learned Standing Council, Secretary Education, shall produce the reports as directed by this court on 31/2023. 31/2023 lists the matter again after you. Can you file your affidavit early? After 4 weeks.
That is the because the division bench order also said that it should be hard.
And then not in that case, yes, the other case.
In the other,
Because they are duty, that is what the mayor duty of the
order is not able. Also, make only consider that the matter should be hard.
Where's the calendar? 13th March. 13th of March, after 4 weeks. That's why I've said. I'm not passing any interim order, so that stands that I'm rejected. It's okay, man, don't worry. Don't worry. No. After issuing notice, when notice, no interim, there's no problem. Yes.
They are in this case machine. There is a year machine. With celebration of service of non-teaching staff of 2018 they are there. A year machine the school was initialized in terms of 2011. I service was there. And in terms of machine, new air machine that is 2018. I submitted a prayer into the inspector school. Place my claim for that year. District is 17. There was a case 80 last time. This so that we can see this video to review. That was the response. That has not been placed.
Yes.
If you go by the rules, number of posts for grade 4 is 1 years. But here and the regular, only one post of probation. That's already been there. I have added that other version. This
Can his case be placed before the district committee? You take instructions and come back. I can't wait like this. But M. Khan, Learner Council for Petitioner, MS P. Mushari, Learner Governor Advocate, Learner Standing Council Secondary Education, some receiving instructions. I'll give you 1 week time. Please, the matter on 17th February.
24, they were getting application.
What? We'll take up at 2.
Visitala.
I sub issue notice. Mr. A. Hussain, Learner Council, enters appearance on behalf of the petitioners, public parties 6 to 16, and press for 1 week time to file objections. Prayers allowed. List the matter again on 17th February.
25 admission.
Thursday, there's a hearing date. Part B, Gogoi and counsel for the petitioner on request made on behalf of P.N. Goswami, then it's counsel for the respondent. Representative Standing Council Excise Department. This is the matter of 9th.
26.
Why tampering? Gogoi?
They have to obtain instruction regarding whether the students survive or not. That's for that.
Okay, then let him take instructions. What is the big petition? He's going to make the same prayer even if your senior comes. Isn't it? You're going to have the same prayer. Okay. Your seniors?
Yes.
And it was made on behalf of P.R. Shittal and the council petition. List of the one.
27. Not working out. Speaker is not working.
You can hear me? Yes. Can you hear me now? Yes, please.
Petition before Lordship. So, Peter Myler. Myler was appointed by the school managing committee Myler. And Myler annexer to page 13 Myler. The school was upgraded as high secondary school. And my post was not for this man. So, notice was in school, issue. But that's when we're not taking to the next of
Yes, who is appearing? Secretary? Yeah, you, Sharma?
Grade 4 employment are yes to follow the procedure manner to select as a grade 4 employment. So, madam, in this regard, I have to take instruction regarding the whether vacancy is here or not, or like.
That's why last time also you were given the time, isn't it? You were given 3 weeks time.
No, my short list is the 19 to 18 minutes.
No, last occasion also he was given 3 weeks time.
Yes.
Which may be instruction.
You end Bora.
Right.
Or then Bora and council. On request made by you, Shamal, and the standing council, secretary education.
There is a vacancy there, my vacancy position is also I annex.
2 weeks, but the time is allowed to file affidavit in opposition. List after 2 weeks.
29 to 32.
Hearing for the petitioner is item number 30 and 31. And in the other matters are for the respondent. So on the request of the person concerned, the client has released the brief. They have taken it over for taking some other terms. So may I present the matter is taken after 2 weeks. In the meantime, you will taking another section completely.
It's for otherwise for instruction from the government side regarding creation of the post of principal.
Oh, the principal creation for.
Lordship has, in fact, Lordship has on the earlier occasion vacated the Indian model and asked the detail. Problem here is not I don't have the brief.
Okay, you are Mr.
I'm B. Sharma.
On request made by Mr.
I'm B. Sharma.
D. Sharma, and the council
Was the petition
appearing for the petitioners in WBC 378,
678, I am.
3723 and 1935
3723 and
and 1935 of
1935 of 2020.
And in the other matters, I am for the
This is the
respondent.
matter after 2 weeks.
Okay.
33.
Where is the language teacher, my lord? And the phone number is the language teacher. But Krishna is the senior student, 7. Language teacher, my lord. Page 26.
Yes,
The approval, my lord. Approval for the, my lord. Bill number 1, Muhammad Ali Sheikh. He is, my lord, this one was 7 million. Date of joining can be 21/6/1999. Next, my lord. Serial number 2, petitioner, my lord. Application Talukdar. Date of joining 10/8/19.
but his date of joining is as headmaster. Respond number 7.
Yes, headmaster, but he is taking my lord language subject matter.
Yes.
Then my lord Chinese my lord is 29 minutes. Particular committed by the headmaster. That's number 7 system committed this particular matter. Page 29 minutes.
Yes.
Serial number 1, Muhammad Ali Sheikh, number 7. He7, date of joining 21/6/1999. And the name of subject taught matter in the right side matter. Column number 12. English. English language subject. Shall not use the traditional matter. And date of joining 10/8/19 and subject taught assembly. It is clear, my lord, I am also language teacher. He is also language teacher, but I am senior than him.
Yeah.
But by my name,
Where is the order?
page 30, my lord, can you see? This is the recommendation, my lord. Yes, and property put in page 31. His name was recommended, my lord, but my name was not. I am
You're not recommended serial number 1.
Yes,
His name is serial number.
his name is serial number 1, my lord, Muhammad Ali Sheikh. Column 6, the top, my lord, Muhammad Ali Sheikh. Recommended. Next, column 7, my lord. Conclusion Talukdar.
Yes.
He is English, I am assembly.
So you are agree by this.
That particularly his service of the provincial my lord. The order I have not approved.
Order you apply the next. What order? What date?
I have 2 minutes. I have
2000.
21. Clear case, my lord. Immediate case, my lord. However, the file manufacture.
You file appeal under section 14. Where is the interim order? Where is the vacation? I disposed of by vacating.
Only that petitioner represented the senior member.
Yes. What do you say?
Petitioner case was not considered as feasible. If this is not considered, then the petitioner can propose that.
That's what I know. Yes.
That is the fair one. Yes, that is fair is not considered by the DHL. That's the way.
Yes. Yeah, Mr.
Yes, sir. Here, they are not putting in the
Heard Mr. H. R. Ahmed, learned counsel for the petitioner. Also heard Mr. P. Dalukta, learned standing counsel elementary education. For respondents, 1, 3, 1, 3, 5, and 6. Finance, Mr. H. Alial, the standing counsel, finance, appears for respond number 2. And Ms. Didi Barman, the government advocate, appears for respond number 4. Stop. Para. The petitioner was appointed as assistant teacher at 4/7 number Bashpari ME Madrasa, situated in Bungaigaon district by an order dated 6/8/1999, to which post he joined on 10/8/1998 as a teacher. For Assamese subject, within brackets, language. Stop. Respond number 7 was appointed on 18/6/1999, to which post he joined on 21/6/1999 as an English subject teacher, within bracket language, in the same school. Stop. The petitioner, cancel it. The services of the teaching and non-teaching staffs of the said madrasa was considered for provincialization, and the district levels and the district scrutiny committee recommended the case of the respond number 7 as linguist teacher. However, the case of the petitioner was not recommended. Stop. It is the further case of the petitioner that the respond number 7, that the services of the respond number 7 has been provincialized by an order dated 5/2/2021. Stop. Being aggrieved, petition is before this court by way of the present petition. Stop. Section 14 of the So-and-so Act provides for an appeal before the State Scrutiny Committee on the recommendations of the district level District Scrutiny Committee. Stop. Accordingly, the petitioner is directed to file an appeal before the State Scrutiny Committee within a period of 2 weeks from today. Stop. The State Scrutiny Committee, on receipt of the appeal from the petitioner, shall consider the same after hearing the petitioner as well as the respond number 7 in person, and thereafter pass an appropriate order in accordance with law within a period of 2 months from the date of receipt of the appeal. Stop. With the proceed of the business directions with petition till the appeal is considered by the State Scrutiny Committee. Interim order passed by this court shall continue.
34.
Say like this, the interim order passed by this court shall continue till the appeal is decided by the State Scrutiny.
This is a case used to in the year 1999, the petitioner was appointed as a grade 4. Then they were terminated. Again, they have come to the petition of the court, then division bench pass an order to regularize. Your lordship knows that because your lordships were there. That case, my lord, Corollary case.
Huh.
Yeah. Then, my lord, till today I have not been regularized. Though there is a court order, till today I have not been regularized. Still, I am working as a gate 4 and I am getting the salary up to 2000 to 2008.
Have you filed your affidavit?
No, lordship, I gave, as per my telephonic instruction, a committee has been formed to look into the dignity of this candidate claim lordship. I have to get the instruction whether the petition gets there or whether any further steps has been taken. Lordship, 2 weeks time.
No, that may be fixed otherwise.
Third, M.S.K. Devil on the council for petitioner. So, Mr. B. Chowdhury.
Yes.
Then standing council BTC submits that he has received a telephonic instruction that the BTC has constituted a committee to look into the
Genuinity of each.
The genuineness of the grade 4 employees, and thereafter thereafter appropriate orders will be passed. Now, he therefore prays for another 2 weeks time to receive instructions. Praise the Lord.
23,
This is the
madam.
matter again.
February
23rd. No, 23 is the hearing date.
hearing day, additional hearing because
24th will have.
24. Earlier.
35.
In this case, lordship, the petitioner, my lord, petitioner, was my lord recommended by the district security committee. On the state committee, my lord rejected, my lord, then was not provisional lordship. On the other, is have to service the no. Dropped.
What? What has happened?
My lord, district scrutiny committee, my lord recommended the petitioner's name. Finally, my lord.
Where is that district scrutiny recommendation?
That is my lordship.
Page 23,
Yes, lordship. My lord, 26 now.
26.
Not 26 is the my lord, consideration order lordship.
No.
20, that starts from my lord lordship, there is 20 lordship. My lord, 21. Starts from verse 21 lordship. My lord, this is first page lordship, 21 times. As city girls.
Where is the recommendation? That is page 23, isn't it?
Name of the petitioner can be seen at page 24. Bottom was.
Where?
I don't know, 20, I'm sorry, lordship, 25 bottom. 25 bottom, last is to my SCP Girls MA Madrasa lordship.
Where is that?
Number, serial number 5 is mine and my lord. Kamaluddin, my lord. Second, before last, third paragraph. From
Kamaluddin,
yes, sir. Serial number 5.
Arabic teacher.
Yes, sir. Arabic is a classical language is a lordship.
Where is the rejection of the state scrutiny?
Pilot test 26 is the pilot order. The list is pilot test 27. Pilot serial number 975. Pilot 3,
Aisha Khatun.
Aisha Khatun, Muslim Ahmed, Publicul Islam. These 3 persons are pilot as people. Arabic is a name madrasa because of having my post of my Arabic is this course name is Arabic madrasa.
Yes. Taluka. To whom should he file the appeal?
It should be the government law.
Who's the government? Who's the government? Secretary? Huh?
Secretary. Principal secretary.
Principal secretary or secretary?
It should be principal secretary.
Which department?
Elementary.
Is there principal secretary elementary education?
Secretary is here, madam.
That's what I'm saying, education department. It has been already amalgamated, isn't it, all departments, so far as the administrative head is concerned. The MH Ahmed. Heard MH Ahmed, level council commission. Also heard Mr. P. Daluttar and Standing Council Elementary Education for respondents, 1, 2, 3, and 1, 2, and 3. And MS DD Barman and Governor Advocate for respondents. So, Farah. Petitioner was appointed as an Arabic teacher, basing on a resolution dated 1/1/1990 of the school SMC of SGT Girls ME Madrasa. Stop. The said school was recognized on 14/12/2005. Was recognized with effect from 1/1/2005. Stop. The appointment of the petitioner was approved by the District Elementary Education Officer, Bongango, by order dated 18/5/2010. And his name was captured in the DIS of 2008-9, 2009-10 onwards as Arabic teacher in the said school. Stop. When the process of provincialization of teaching and non-teaching staff of the STG Girls ME Madrasa took place, the District Scrutiny Committee recommended the case of the petitioner for appointment recommended for provincialization as an Arabic teacher. However, the District Scrutiny Committee rejected the case of the petitioner and instead provincialized the services of 3 other teachers as tutors. So, being agreed, petitioner is before this court. So, Section 14 of the Act of Swenson provides for an appeal against the recommendation of the State Scrutiny Committee before the state government. But accordingly, petitioner is directed to file an appeal before the Principal Secretary, Education Department, Assam. Stop. On receipt of the appeal, the Principal Secretary Education Department shall consider the case of the petition shall consider the appeal filed by the petitioner after giving a personal hearing and after pass adequate orders in accordance with law within a period of 2 months from the date of receipt of the appeal with the aforesaid observations and actions with petitions dismissed.
Madam, instead of principal secretary, Department of School Education. Now,
Or the Department of School Education.
36.
Well, in this case, the ratings and everything is, he was a director of Guwahati distance learning course. There were some courses introduced which were said to be not recognized by the DEC in Delhi. So that's basically the charge. Now he has been removed. It takes some time. It can give me a date for a hearing. So that both others are trainings are complete. Mr. Kane was the case for the Guwahati University.
give a convenient date.
My lord,
Court of Appeal.
Mr. Chaudhary will not be here from 12 to that week, my lord. The week next, whenever it's, my lord's board is permitting, my lord.
After 25th February.
Yes, 28th, my lord.
Okay. On request made by the parties, list this matter on 28th of February.
37.
The petitioner is the senior most individual, your lordship. He has been,
Have you completed the SSA? Have you completed SSA?
Yes, your lordship. Your lordship may kindly reduce sheet number 19, and it's a B. This is the resolution by the managing committee, your lordship.
No, I'm asking you one question. Have you completed the SSA? Assam.
Yes, your lordship. You
Have you completed? Then that was the order passed.
as per the last order, you will take steps.
Where have you taken steps? Where have you taken steps? I see no steps being taken by you.
Then your lordship, I will do that.
You are Mr.
R. Das, your lordship.
R. Das, Mr. R. Das, then the counsel for petitioner. Press for how much time?
2 weeks, you know.
2 weeks time to take appropriate steps for implementation of the SSA Assam. Stop. Praise alert. List the matter after 2 weeks.
Either
38, 39, and 40.
Why not your lordship is to pay Article 39, right? He made the government requiring immediate review. And that is 39.
30?
39. I mean, giving at 39 and 40.
Yes.
So why not, by order dated 13/5/2020, this court allowed an exhibit on IA, which was filed for hard hearing in Article and just provided that that the matter be listed on 14/6/2022 in the Education Parliament, and attempt could be made to dispose of the petition at the admission stage. So
Yes.
after all subsequent days, it was expected that it would be taken up for disposal. And meanwhile, the pleadings are also complete. So, pleadings are also complete. So the matters relates to
Item 31, 39 pleadings are complete. How about item 38?
if item 38, the government has not filed affidavit, and when I requested in the form of affidavit for these are similar matters, analogous matters. So my learned friend, in this case, the responsible government has filed the affidavit, and I have adopted the affidavit. It's like I said, I responded back.
Yes, Talukdar, have you filed? Who filed the counter? Elementary education is fine. You file your affidavit.
Yes, madam.
Have you received a copy?
In fact, when I requested them, I used to give it a copy. As I used to common affidavit, common matter, just file affidavit. I just got copy and so. instead of-
You are the petitioner in?
In 30, item 38, madam.
Yes. So you're willing to proceed without the affidavit?
I'm relying on the affidavit, reply submitted, I want to the affidavit we have submitted. And also the reply submitted by number 10.
So without receiving the affidavit in opposition, you are ready to proceed? Okay.
The other side is ready.
Yes, Talukdar.
Madam.
What is this?
Sorry, madam.
Case is listed, you come unprepared. I do not understand.
So, matters may not relate to giving marks for experience of the contractual teachers in the direct.
Bora, you are appearing for the SSA here. Okay. Yeah, Talukdar, when do you want? Next time, I'm not going to be very lenient.
Ask them about whether
Yes.
what is
Heard Mr. M.H.R. Borgohin, London Council for Petitioner in WBC 782/2022, as well as Mr. O. Laskar, London Council for the Petitioner in WBC 526 of 2022. On request made by Mr. P. Talukdar, London Standing Council, Elementary Education. List these matters again on 14th February. You come prepared on the day.
41.
What the matter relates to belongs to the cause of action arising pursuant to an impugn order belongs. All of this is to find the impugn order is in page 22. An order by which my charge has been cancelled and the charge of the headmaster has been conferred to the private respondent. Initially, I was allowed to hold the charge on the strength of an order. All of them is pleased to find that page 20, annexure 3. Until further order below, the petition Provin Sharma Swaincho, assistant teacher of the Bogamo Girls High School District, Yamati, is thereby allowed to hold the charge of administrator in charge of the same school, along with the financial power to draw and disburse the salary, etc., of the staff of school in addition to her normal duties as assistant teacher under Swaincho. While Sri Kusheshwari Gogoi, administrator, retired on 10/6/2019. However, not the date. This was issued on 10th of July 2019. Accordingly, I was continuing and discharging my charge, and suddenly, after a gap of 3 years, page annexure 4, page 22, an order has been issued that the until further order, Srimati Swaincho, BA, assistant teacher of the Bogamo Girls High School District, Yamati, is thereby allowed to hold the charge of administration in charge of the same school, along with the financial power to draw and disburse the salary, etc., of the staff of school, in addition to her normal duties as assistant teacher under Fundamental Rule 49C I be present headmaster Sri Govind Sharma Bas, B.Ed, under CMJ University, which does not bear validity to be a headmaster of a high school. Formula, for 3 years, I was valid. I can continue and discharge my duties. Now, suddenly, Milord, after a gap of 3 years, I have become invalid. That about, Milord, this is an arrangement, temporary arrangement has been made. My Lord, my Lordship is well aware, Milord, that this is an ad hoc arrangement, and which I am continuing from the year 2019 to 2022. Now, suddenly, Milord, my ad hoc has been replaced by another ad hoc. So, Milord, this is prima facie is illegal in view of the Milord, the Honorable Apex Court judgment, which is saying, Milord, that one ad hoc cannot be replaced by another. Now, Milord, the issue of qualification will come. Milord, that they have said that my CNJ B.Ed degree, Milord, is not valid. My Lord, I am sorry to mention, my Lordship has already heard the issue, Milord. We are awaiting the judgment, Milord, regarding that B.Ed degree of the CNJ University. So, till the issue is, Milord, under sub judice before this honorable court, the authorities could have waited, Milord. Could have waited till the whether my degree is valid or not. In fact, Milord, I am the senior, Milord. If my Lord will be pleased to take up the seniority list, Milord, I have annexed that. My Lord may be pleased to find annexure 1 is the list of the teachers, Milord. The petitioner is Milord Govind Sharma. My Lord may be pleased to find.
Serial number 6.
Yes, Milord, serial number 6. My Lord may kindly note the date 30/10, Milord 1986. Now, Milord, this Kusheshwari, Milord, the Bhavani Hazarika, Milord, that's only qualification is in dispute. All the time placed by the two madam. But we are taking it legal. I have noticed. And it is.
You are appealing for?
I'm for private respondent.
Yes. State.
They have not filed affidavit.
Why? This is a simple matter. All you have to explain is why you have removed the petitioner just because he has a B.Ed degree from CMG. What made you come to the conclusion that the B.Ed degree from the CMG is invalid? That's the only thing. It's just a 2-page affidavit will do. Have you received instructions at least? How much time do you require? Or at least get some instructions and come back. Some written instructions, no need to file an affidavit. Then we can dispose of this. Heard Mr. A.R. Buyan, then the counsel for petitioner. Also heard Mr. K. Burrow, then the counsel for the respond number. 4. Stop. On request made by, I'm sorry, I forgot your good name, please. T. Musari, Learner Standing Council, Secondary Education. How much time will 2 weeks time is allowed to enable me to receive instructions? List up to 2 weeks. You want the date? 22nd. February.
42.
Look, the last occasion also court made a observation that it has.
Good morning. I have received instruction, madam. Object may kindly allow me some time to file it or dispose of the matter in the light of my section 14.
Yes, proceed.
There is no private testimony. Kindly say that. My appointment is 22 months.
That we have seen. Then what happened?
Page 31 line is it.
Page?
Page 31, this is the recommendation number. One, and operating question, page 32 line.
Yes.
The phone numbers of business have been recommended by the- my name is there number 4 madam. Chittaranjan Shodha. Social science.
1 minute. Who is your name?
Chittaranjan, column number 6 madam. But middle madam.
Chitaranjan,
Chittaranjan Shodha.
social science.
Social science. And above me madam, Kalipada Saha is language madam. And Joy Gopal is language. And Vishnu Gopal is mathematics. Two language teachers has been recommended, and I am the only social science teacher. And in the meantime, my lord, Joy Gopal they already retired my lord on 8/1/21. Joy Gopal they already retired on 8/1/21. So probation.
Before provincial.
So only 3% oil late.
Then
But they have probation with 2 my lord. Kalipada and Vishnu Gopal assessment.
who is the scrutiny?
Page
State
34 is the list, my lord. Published.
this from the state scrutiny committee.
Yes, my lord.
Where is your school?
Shahid Memorial in school. And Kalipada Shah, Joy Gopal, the name was there because my lord, his name was recommended by the Central Committee, my lord. Before my lord, he retired on 8/1/21 and this is published on 4/2/21. This was published 4/2/21 and subsequently on 5/2/21 further publication was. So he was known to only 2% also listed. I am social science.
Yes, Talukta.
Social science.
Kindly come to page 35, the next slide. It's already filed representation before the bank. Directly to consider its representation.
This is aggrieved by the recommendation of the state scrutiny committee. He has made a representation before the state scrutiny committee again. He has to go before the state government. So this representation does not.
I will place it.
Hurt Mr.
Yes, sir.
H.R. Ahmed when it comes to petitioner. Also heard Mr. B. Talukta, then the standing council, elementary education for the respondents. 1, 2, 4, and 5. And MS D.D. Barman and the government advocate for respondent number 4. Stop. Petitioner was initially appointed as a science teacher on 15/1/1991 at Swahid Memorial ME School, within bracket Bengali Medium School, to which post he joined on 21/1990. Stop. Basing on a resolution passed by the SMC of the said school, held on 10/6/2007, petitioner was allowed to work as assistant teacher. Stop. The post of the petitioner was approved by the district elementary education officer, Dugre, by an order dated 7/12/2007 as assistant teacher. Stop. As assistant teacher, social studies, within bracket social studies. Stop. During the process of provincialization under the so-and-so Act, the Act of 2017, the case of the petitioner was recommended by the district scrutiny committee as as social science tutor. Stop. However, the state scrutiny committee rejected the case of the petitioner and instead provincialized the services of 3 other tutors. No, but the three other tutors. Stop. May I give petitioners before this court? Stop. Section 14 of the Act of 2017 provides for an appeal before the state government on the recommendation of the state scrutiny committee. Stop. Accordingly, petitioner is directed to file an appeal before the principal secretary, school education.
Department of Student.
Hmm?
Department of Student. Department of Student.
Department of School Education within a period of 2 weeks from the drafted, Principal Secretary School Education shall consider the appeal filed by the petitioner after giving a personal hearing to the petitioner and draft a pass of orders in accordance with law within a period of 2 weeks from the date of receipt of the appeal with the officer of submissions and directions to the petitioner's district.
43.
That this is Dr. Heather will be passport timely. My serial meeting is on legs, put on the 6th.
I have one petition on the issue is, I think some hearing is required, but one the issue is that, my guide, under whose, guides, if I completed my MPhil, he is now behind me for not allowing me to get enrolled in the postgraduate courses in the Cotton University. And, there is a specific allegation has been made against that person, the respondent number 4. I have made the respondent number 4 as the first respondent. That that due to his attitude and his conduct, I am not being allowed to take admission in the postgraduate courses in the Cotton University. Now, the respondent number 4 I have made, and we have also sent copies up to him, but he says none has appeared on his behalf. If my lord will please to take up the petition,
1 minute.
They are saying that this matter will be fixed on next Thursday or the coming next Tuesday. That's a hearing item. Some hearing, so
Yes. But they are there and it comes over the petition. Only question number 59 and standing council, Cotton College. Cotton University. Is the matter 22.
46 order.
Exceeding one week, there will be granted for taking 6 days. That's to item 6.
MSK Devil and the council for petitioner press for the week's time to take fresh steps for service of notice and respondents 5 and 6 by registered post AD.
Yes,
By registered post AD. Stop. Praise the Lord. List the matter up to 4 weeks.
47.
Order matters. Why do you need a senior counsel? effort, Mr. You be- F. Farooq, learning counsel appearing on behalf of Mr. S. Haq, learning counsel for petition. Stop. Peruse the proceedings of the Lawazima Court dated 27/1/2022. Notice on the for respondent. Mr. Khatania. I just need your help. This is Mamta Hoja is still the director of secondary education. Can you take dusty service? Dusty service. Oh, this is a contempt matter. Oh, so can you take first steps? Then the counsel for petitioner is allowed to take first steps on the sole respondent by registered proceeding within 1 week. from the date. List the matter again after 4 weeks.
48.
So this is a contact petition, Your Lordship. And as per office note dated 3/2/23, neither any nor answer was received. We have taken steps as per the new equipment.
You've taken steps.
Let the matter get placed before notification.
Registry is directed to place this matter before the Lawazima Court. To ascertain whether notice on this on the response number 2 has been served. on it. List the matter again after 2 weeks.
49.
Third J. Payang, learner counsel for petitioner. On request made by NG Khatania, learner counsel for response number 1. How much time?
3 weeks.
3 weeks time is allowed to file affidavit. Please start the 3 weeks.
50.
It was a contempt.
Very good. For your lordship, the record number is
Okay, Mr. A. Dekha, learner counsel for the petitioner. Please, for how much time you require? For 2 weeks time to file reply to the affidavit filed with respondents 1 and 2.
2 and 3.
2 and 3. MS Artist Dury, learner counsel appears for respondent number 3. So, this the matter after 2 weeks.
51.
Matter relates to selection of a lecturer in a particular college. Earlier, my lord, an advertisement was issued. Then, my lord, in the advertisement, one, Srimati Bidisa Borduhai was selected. We assailed the selection of that Bidisa Borduhai, my lord, and her sorry, in that selection process, the petitioner, amongst others, one Dr. Brojan Sharma and Srimati Bidisa Borduhai participated. Now, my lord, in this selection that took place on the first occasion,
The petitioner secured 65, 6.5, they are 5 more marks. But what happened, my lord? Initially the authority recommended the name of one Vidisha Borgomai. Now, that if the authority themselves found that Vidisha Borgomai, she was not eligible for certain marks. Therefore, my lord, her recommendation was withdrawn. And my lord, the post was sought to be purportedly again reappointed. At that stage, my lord, we approached this order. That is WPC number 5663 of 2020. My lord, there lordship has passed an order. If lordship would kindly have that order, my lord, at page number 45. And operative portion is at page 47. Page 47. Be that as it may, we have gone to the resolution number 4 dated 3/12/20 of the governing body, and we found that no reason as such were assigned by the governing body why the selection process pursuant to advertisement dated 11/8/2020 was cancelled, requiring re-advertisement. J. Payal Learning Council for Respondent College states that there is a possibility that decision to re-advertise was because of communication of Director of Higher Education Assam dated 30/11/2020, which required that selection committees not to recommend 2 or 3 candidates in order of merit, which will be in violation of 6 and 7 of the AFR-DM Act 2005. Even if that is the reason, we are of the view that such reason would be untenable, in as much as AFR-DM Act nowhere provides that if selected candidate was ultimately found to be ineligible, the matter cannot be remanded back to the selection committee for proper adjudication, and there has to be a re-advertisement. For the above reason, we find a resolution number 3/12/2020 of the governing body of the Silapatra College to be unsustainable in law. Accordingly, same is set aside. The matter stands remanded back to the authority of the Silapatra College to bring the process of selection for the post of assistant professor assamese pursuant to advertisement dated 11/8/20 is logical end. Consequently, if there is any further re-advertisement, the same also stands re-advertised. Pursuant to this order, my lord, what they did, they purportedly carried out the selection again, and thereby, my lord, the respondent number 4 has been selected, recommended. They were recommended to the director. Now, at that stage, we approach this honorable court, where there is a stay order, my lord, whereby the director has been directed not to give approval to the recommendation. However, the reason why I have not been selected is a very funny reason. What has happened? Pursuant to the 11/8/2020 advertisement matter, there was a selection, pursuant to which Vidisha Borgomai was selected. In that, my lord, I submitted all my resumes, and thereafter I was returned with all the documents. Now, my lord, in the first selection, certain marks which I secured in that first selection have not been given to me on the ground that I have not produced the original. That is not the purport of the order of the single judge. Purport of the order of the single judge was, my lord, to take the selection is logical because you have already held the selection. Now you yourselves have withdrawn the selection of Vidisha Borgomai. Among the rest candidates, whatever happened on that day, you have to make the selection. Instead, what they did, my lord, they have given me 4 marks less this time because purportedly I did not submit some original documents. How can they do that, my lord? On the first occasion, I have already got 66.50 marks. Now, what has happened? This respondent number 4 who has been selected, he is already working somewhere else. That's why he has not bothered to respond to this notice.
Oh.
He has not appeared, by the way, in spite of receiving them.
That's why it's coming for orders.
It's every time.
Let's see.
My humble submission is, my lord, I am the eligible candidate. My case is considered by the governing body. And my lord, please come to page 55, my lord. There is a OM by the state government. After, at page 55, After selection of any state government job with effect from 1st of August 2016, employees are not allowed to apply any other state level government job in the same position. Page 55. It's 25th of June 2020, madam.
2016.
16, I'm sorry, yes. After selection of any state government job with effect from 1st of August 2016, employees are not allowed to employ any other state level government job in the same position up to a maximum period of 3 years. If unknowingly any state government employee do so, his candidature will be cancelled from both parties. In any case, my lord, he has received notice from the government. He is not appeared because he is already working somewhere else. But college does not get it. I don't know what is their vested interest. Allah, let them produce. I'm sure my management is having the record. If the records are produced, it will be, I mean, clear, my lord. Then in fact, I am entitled to get 66.50 marks. And the person who has been selected, he also, his application is also deficient. And my lord, he has been given more, 4 marks more. Allah, the fact that I got 66.50 of the asked election selection, then merely because High Court says you take the process to logical end, how does my lord 4 marks can evaporate my lord?
Yes, fine.
I find this I find it for longer. And not and this is first time when I'm coming. It's not that kind of this case of speak for stability. This should have come in this stage.
You want to vacate the order for a party who has not even appeared? I know for the college.
I put the policy.
No, college is
It's for the interest of the policy. This is the first time that the order. Otherwise, it was listed earlier for stay vacation. All this time. Stay.
No, maybe because the private respondent in the writ petition is not agreeing.
not appeared as of.
And now, my lord, my first point is my lord. I have tried
1 minute. Is the response number 4?
Yes.
What is this?
This case was and I tried to also because the director has yet to take any decision. So far, the minor judgment, you last was the chief man, the director will consider also before taking any final decision.
Already an interim order was passed, restraining the respondents not to fill up.
After the recommendation was sent to the government, the director yet to take any final decision.
Just a minute. Anyway, today it's coming up for orders. I have to see whether. No, what do we do, Mr. Chowdhury? So far as respondent 4 is concerned.
The
problem-
because as I said, finally he's already doing a job in a college. Is college for nothing? But there's a note by the Lordma Code also. I think the service has been made. My lord, he has been appointed in the Department of Assamese at Government Model College, Ithor in the district of Kargil.
When was this?
My lord, on 2012, 2020, he was appointed. 2 years back.
after the selection process of the present college is completed. That cannot be done. Process, minor process is present.
Okay, whatever it is. In the main petition, right, heard Mr. K. Chowdhury, then the senior
My
counsel,
only thing is, my client is suffering from some early date.
assisted by Ms.
M. Mohan.
M. Mohanda, then the counsel for petitioner. Peruse the proceedings of Lavazima Court dated 22/8/2022. Notice on the respond number 4 shall be deemed to be complete. Stop.
Or my lord, can it be done this way, my lord? Whatever demands we have, we can place it before the director. Director will consider, till then, my lord, he will not give it. And director will also take note of the fact.
What I'm thinking about is respond number 4. So I'm passing an order that his notice is complete.
Complete.
Then on the next day,
Lord will hear it.
we'll hear it. Not today. Today I'm passing an order on respond number 4. Should be deemed to be complete. I'll give you a week's time or 2 weeks' time. Whenever you want it, we can fix it. List these matters. Again on. When do you want?
Actually,
Next to the next.
Lordships can have it on, my lord, 23rd, my lord, February.
That's the hearing day.
Or on 27th, my lord, is a Monday.
Yeah, 27.
Proposition is covered by my lord, sir. I just started.
Three of supplementary.
Yes, you file your Bakalat Nama. One minute. Where's the petitioner's counsel?
Because of may not be interested, because of I am selected as a president of the school managing department. Challenging my selection to that. Earlier one reputation was filed, that was this case. Subsequently, this reputation filed by another selected, not selected, in the list of the categories. So,
None appears for the petition. Mr. You are
thank you.
A.K. Hossain, member of council, appears for respond number 7. And Mr. S.R. Barra, the standing council, government advocate, appears for respond number 2. Stop. Peruse the office note dated 2/2/2023. Stop. The notice of its contents 5, 6, and 8 shall be deemed to be complete. Mr. U. Sharma, then the standing council secretary. Standing appears for the secretary department. List the matter after 2 weeks for admission. Yeah, that will not be. An endeavor shall be made to dispose of this petition on the next of dates. I said 2 weeks, let it come out after 2 weeks.
54.
This matter, my lord, today morning I have the instruction to appear on behalf of the respondents number 1 to 7. And filed by author Salom.
Respond number
1 to 7, my lord.
how about the private respondents? You've taken first steps. Oh, you want
I
to,
have to take, my lord.
then why have you not taken?
I have from Morton order, this notice is neither editor nor answer notice received.
But you are Mr.
Yes, sir.
Is Daslan counsel for petition? Mr. R.M. Dekal and the counsel enters appearance on behalf of respondents 1 to 7. Then the counsel for petition is permitted to take first steps for service of notice on respondents 8 to 11 by registered post 80 within 1 week from today. This the matter again after 4 weeks. Interim order passed to continue.